10 seconds to go. The questions themselves arise in the backdrop of Rules 45 and 46 of the Trademark Rules 2017, and which speak of a deemed abandonment of the right to adduce evidence in support of opposition and in support of the trademark application as a consequence of a failure to comply with the timelines prescribed therein. Rule 45 enables an opponent to lead evidence in support of opposition subject to the prescription that the same must be filed within 2 months from the service of a copy of the counter statement. In terms of Subrule 2 thereof, if an opponent takes no action in terms of the substantive provision made in Subrule 1, it shall be deemed to have abandoned the opposition. A similar right to lead evidence is conferred upon the trademark applicant while responding to evidence in support of 2023 SCC online rules opposition. Here too, the trademark applicant is enabled to adduce evidence in support of the application and thus seek to overcome the opposition which stands mounted. However, the applicant faces a similar specter of deemed abandonment if evidence is not submitted within the time prescribed. According to the opinion rendered by the learned judge in SAPSE, the 2017 rules have introduced procedural changes and would thus apply retrospectively to ongoing proceedings, including those which may have been initiated under the Trademarks Rules 2023. The learned judge in SAPSE, while framing the order of reference, was essentially held that actions validly initiated under the 2002 rules would be governed by the 2017 rules upon their promulgation. The learned judge was further of the opinion that since the decision taken upon SAPSE's application to lead evidence in support of the trademark application came to be rejected in 2019, and thus at a time when the 2017 rules had come into force, it should have been examined as per the 2017 rules. The aforesaid fundamental premise is based upon the concept of deemed abandonment having been introduced only by virtue of the 2017 rules and the applicant there having avoided abandonment, bearing in mind the nature of the representation which was submitted to the registrar of trademarks. The learned judge has in this regard held as follows. The upshot of the above discussion is that due to the procedural nature of 2017 rules, the examiner has erred by applying the 2002 rules on the date when the same had been repealed. The 2017 rules do not contain any clause that provides that the pending proceedings are unaffected and are to continue as per the 2002 rules. In absence of any saving clause under the 2002 rules, Registrar 2017 rules, in the opinion of the court, the registrar ought to have decided the matter by taking into account the provisions of Rule 46 of the 2017 rules and the provisions of Rule 51 of the 2002 rules would not apply. On this issue, The court further takes note of the decision of a coordinate bench of this court which was delivered after the present case was reserved for judgment. In the aforesaid decision, the court has taken a view that the proceedings which were initiated under 2002 rules would have to be adjudicated under the said rules. Analyzing Rule 158 of 2017 rules, it was held that the expression without prejudice to anything done under such rules before the coming into force of these rules would include the filing of evidence in support of the opposition by the appellant therein and would thus be governed by the 2002 rules.